Well, the U.S. Supreme Court hears arguments today in a case that may throw a monkey wrench into the widespread use of DNA testing. Maryland joins 27 states and the federal government in enacting laws that allow automatic DNA collection from people at the time of their arrest. The question now is whether it is unconstitutional to do that without a warrant and for the sole purpose of checking the sample against a national database. The defense, a lawyer in the case, points to the intrusion of DNA sampling and says the act violates the Fourth Amendment. But University of Maryland lecturer and criminalistics consultant Thomas Mauriello says the act is no different than traditional fingerprinting.
When somebody's arrested, their fingerprints are taken. Their fingerprints are a form of identification. The portion of the DNA that the police use to put in a database is for identification only. So I'm glad it's going to the Supreme Court, so there's no more issues. I hope, obviously, that they're going to agree that it does not violate the Fourth Amendment and that the police can continue to do that because it's vital to cold cases and cases where DNA has been found at a crime scene but there's no possible suspect. Cases years later are done through the proper process using the FBI CODIS database.
And the case before the U.S. Supreme Court stems from a 2009 arrest of Alonzo King, a Maryland man who was arrested for assault, but after being swabbed for DNA, was linked to a 6-year-old rape case that had gone cold. King was later tried and convicted of rape and sentenced to life in prison. The conviction was later thrown out by the Maryland State of Appeals on grounds that the DNA was not used to prove the initial assault charge.